Gray divorce is not a term found in statute or case law. Rather, it is a term used to describe older adults ending their marriages. Let's explore gray divorce when competency is in question in Ohio. While an aggrieved spouse in a long-term marriage can question the departing spouse's mindset, the mindset of each party merits consideration by a domestic relations practitioner. Ohio law does not prevent a divorce if one of the spouses is determined to be incompetent, but careful consideration is given when competence is questioned. If a divorce action is filed after a spouse has been declared incompetent, service of the divorce papers must be made on the guardian. A guardian may file for divorce on behalf of an incompetent person. The process is more complicated in proceedings where a person's capacity to take proper care of himself or property is questioned but the person has not been adjudicated as incompetent. Ohio law vests all adults with the right to direct their personal affairs according to their wishes, including divorce litigation. The Ohio civil rules permit a trial court to appoint a guardian to represent an adult only when the court has adjudicated the adult to be incompetent. The law requires that a competency hearing be held before a court treats a divorcing spouse as if they are mentally incompetent. Only the probate court can determine a person's competency. If spouses enter into a separation agreement that is adopted by the court in a judgment entry that terminates the marriage and one spouse later claims that they were incompetent when it was entered into, then, if a court concludes that one of the spouses was incompetent, the agreement may be set aside. Ethical considerations. Ensuring mental competence in divorces involving elderly spouses is critical to reaching a resolution that is fair, just, and equitable. Often, in family law, legal advocacy often requires compassionate guidance. If your family finds themselves in this situation, contact Mary Satera or Roger Kleinman at 216-621-7860.